Our next case concerns pretrial motions made by a mortgage company which challenged a municipality's assignment of a tax title. This land court case is LHPNJ LLC versus Jefferson Development Partners LLC. Jefferson Development Partners LLC owned a 42-acre site in Taunton, which contained numerous interconnected buildings comprising an old textile mill. The collector made a tax taking in August of 2015. When full payment was not received, the Taunton treasurer filed a petition for foreclosure in land court in April of 2016. In February 2018, LHPNJ, which was assigned the tax title, filed a motion in land court to replace the city as plaintiff in this foreclosure action. The land court granted the motion, and a special citation was issued by land court describing LHPNJ as the new plaintiff. A mortgage holder on the subject property, Whittington Holdings LLC, objected to the substitution of LHPNJ as plaintiff and claimed the assignment of the tax title was invalid since Taunton had not complied with the provisions of the assignment statute. The statute, Chapter 60, Section 52, required a public auction with notice to the owner of the property. Taunton had originally scheduled the auction for April of 2017, and then the auction was rescheduled for October 2017. Taunton did not provide the mortgagee, Whittington, with direct notice of the auction. Notice, however, was posted at City Hall and the Taunton Public Library. The minimum bid per the notice would be the aggregate amount of outstanding taxes, interest, and fees, which was in excess of $1.2 million. In early October of 2017, the city sent the owner, Jefferson, by certified mail, a letter with notice of the auction to take place on October the 25th, 2017. The letter was sent to Leominster, Massachusetts, but returned by the post office due to an incorrect street address. At the auction on October 25th, LHPNJ, the sole bidder, purchased the tax title for an amount slightly higher than the $1.2 million minimum bid. The mortgagee, Whittington, alleged the city's auction notice was improper since the rescheduled auction date was not listed on the city treasurer's website. The land court rejected this claim since the notice on the treasurer's website, in its view, was gratuitous, and the city had adhered to the statutory requirement by posting notice at City Hall and the public library. Whittington also claimed that Jefferson was not provided with notice since the city's letter was sent to an incorrect address. LHPNJ responded with an affidavit from one of its officers that an officer of Jefferson Development had accompanied the LHPNJ official to City Hall on the day of the auction. For this reason, LHPNJ claimed Jefferson knew or should have known of the auction and could not now complain about errors in the address listed on the envelope. The land court held that this affidavit raised a question of fact on the subject of notice, which would have to be determined later by the court at trial. Whittington also argued the tax title assignment was invalid since Whittington, as the mortgagee, was not provided notice of the October auction. The land court rejected this argument since the assignment statute, Chapter 60, Section 52, by its terms, did not require municipalities to give notice to mortgagees. In the court's view, there was also no authority for the constitutional argument that due process required notice of a tax title assignment auction be provided to a mortgagee. The court reasoned that a mortgagee by state statute presently had the right to request that tax notices be sent to the mortgagee by the municipality. Whittington had not made such a request, and the court's view, therefore, it was unnecessary for the land court to address Whittington's due process claim. Whittington then questioned the $1.2 million redemption amount as excessive. The primary reason for the large amount was the city of Taunton's fire watch liens. The Taunton Fire Department had notified Jefferson, as property owner, that this old mill complex lacked a proper fire protection system, with its failing automatic sprinkler system and inadequate automatic fire alarm system. When the owner did not make the necessary repairs, the Taunton Fire Department conducted a fire watch at the mill 24 hours a day, 7 days a week. The fire watch meant that a Taunton firefighter was stationed outside of the mill in a van with the job of monitoring the mill and reporting immediately if there was a fire. The first fire watch began in January of 2013 and continued until March of 2014. The second fire watch began in June of 2015 and ended in September of 2015. By state statute, Chapter 148, municipalities can abate hazardous conditions and charge abatement costs, which can be liened to the subject property. The costs incurred with these fire watches were in excess of $450,000. Whittington argued that Taunton had not perfected its lien under Chapter 148, since an account for the amount due had not been rendered to the building owner upon completion of the abatement, and a statement of claim had not been recorded to the Registry of Deeds within 90 days after such debt became due. Whittington also claimed that if the city's fire watch liens were perfected, the building owner and the mortgagee were denied due process, since there was no mechanism to contest the charges that were imposed. Whittington also requested the land court to abate some of the interest charges that were included in the redemption amount. The land court held it would determine at trial whether the city's liens had been perfected, and if so, then address the mortgagee's due process claim. The land court has not yet issued its decision.